Unit 3 of international law is the relationship between international law and municipal law. So, international law, we have been studying what is international law. What is municipal law? Municipal law are the national laws. Whatever the legislations are in India, it is only for the territory of India. So, that will be the municipal law, and international law will be the treaties, conventions, customary laws that we have studied about. So let's understand the relationship between these two. To understand the relationship between international and municipal law, which are two different legal systems which coexist and influence each other, we have to understand the two main theories, that is monoism and dualism. So these two theories have different stand in terms of international law and municipal law. So let's start with monoistic theory. So this theory, the word mono means single. So the first point is international law and municipal law form a single unified legal system. It is stating that there is no different legal system, दोनों same है. This is by monoistic theory. Next is hierarchy. तो इसमें बोल रहा है कि कोई hierarchy भी नहीं है. There is no fundamental difference between two because both are same. Third is primacy of international law. So if there is any issue or law which is given under municipal law and international, and both are in conflicting nature, then international law will prevail. तो ज़्यादा importance international law को देता है monoistic theory. Next is direct applicability. It means that अगर कोई भी इंटरनेशनल लॉ एग्जिस्ट करता है, अगर आज के डेट में एग्जिस्ट करता है, टेक सम एग्जांपल लाइक राइट टू प्राइवेसी शुड बी अ फंडामेंटल राइट, विच इज अ फंडामेंटल राइट इन इंडिया, बट लेट्स टेक एन एग्जांपल. तो आप डायरेक्ट वो म्यूनिसिपल लॉ का पार्ट बन जाते हैं. इंटरनेशनल लॉ इज सेइंग राइट टू प्राइवेसी इज एन इंटरनेशनल लॉ, मतलब डायरेक्ट एप्लीकेबिलिटी है, कोई जरूरत नहीं है अलग से लेजिस्लेशन या अलग से जजमेंट देने का कि वो लॉ बन पाए. International law is saying it automatically becomes part of any nation's legal system. नेक्स्ट इज फिलोसफिकल बेसिस. अब इसका जो बेसिस इस थ्योरी का वो है नेशनल लॉ थ्योरी. सर नेशनल लॉ थ्योरी क्या बोलता है? that all the sources that all the laws should be from the same sources, that is justice and morality. So this is the monoistic theory. So first point is एक ही system है, both international law and municipal law is same. हायरार्की में कोई फंडामेंटल डिफरेंस नहीं है. थर्ड इज प्राइमेसी, ज्यादा सुप्रीमेसी इंटरनेशनल लॉ को मिलेगा इन टर्म्स ऑफ म्यूनिसिपल लॉ. डायरेक्ट एप्लीकेबिलिटी है, कोई जरूरत नहीं है अलग से लेजिस्लेशन या कुछ जजमेंट देने का. इंटरनेशनल लॉ इज सेइंग दिस, सो इट विल बिकम पार्ट ऑफ स्टेट्स लॉ. नेक्स्ट इज इसका फिलोसफिकल बेसिस नेचुरल लॉ थ्योरी से आता है, जो बोलता है कि सारे लॉस का एक ही सोर्स होना चाहिए, एंड दैट इज जस्टिस एंड मोरालिटी. सो अब इसका एग्जाम्पल क्या है? सो बहुत सारी कंट्रीज है जहां मोनोइस्टिक थ्योरी चलती है. So one more thing, it depends on each country to adopt whether monoistic approach or dualistic approach. So एक ऐसी कंट्री है लाइक नेदरलैंड में कॉन्स्टिट्यूशनल प्रोविजन से भी ज्यादा इंपॉर्टेंस दिया जाता है इंटरनेशनल ट्रीटीज को, इंटरनेशनल लॉ को, देन डोमेस्टिक लेजिस्लेशन. So example of monoism is present in Netherlands and some other countries. नेक्स्ट इज डुअलिस्टिक थ्योरी, और डुअलिज्म भी बोलते हैं इसको. सो फर्स्ट पॉइंट है सेपरेट लीगल सिस्टम. सो द वर्ड डुओ मीन्स डू. So it is saying that international law and municipal law are two different legal systems that operate independently of each other. नेक्स्ट इज ट्रांसफॉर्मेशन और अडॉप्शन. तो इसका अडॉप्शन कैसे होगा? ऑटोमेटिक नहीं होगा जैसे मोनोइस्टिक में हो रहा था. इफ देयर इज सम लॉ और प्रिंसिपल इन इंटरनेशनल लॉ, so in order to become a part of municipal law, a legislation has to be made. So it should be a legislative process through which we are adopting the international law and making it part of our domestic laws. Third is state sovereignty. Sovereignty का मतलब होता है freedom from any foreign influence या फिर external actors से influence, and state can take their own decision. So this theory give more importance to state sovereignty. जैसे मोनोइस्टिक में क्या था, अगर इंटरनेशनल लॉ है तो वो म्यूनिसिपल लॉ बन जाएगा, बट यहाँ पे ऐसा नहीं हो रहा है. यहाँ पर स्टेट के पास सॉवरेन राइट्स है, उसके पास खुद का डिसीजन लेने का, दैट वेदर दे वांट सच लॉ टू बिकम पार्ट ऑफ देयर लीगल सिस्टम. नेक्स्ट इज नो डायरेक्ट एप्लीकेबिलिटी. अगेन अगर इंटरनेशनल लॉ को पार्ट बनाना है डोमेस्टिक लॉ या म्यूनिसिपल लॉ का, देन देयर शुड बी अ लेजिस्लेटिव प्रोसेस, इनैक्टमेंट होना चाहिए, जजमेंट के थ्रू होना चाहिए, वो ऑटोमेटिकली पार्ट नहीं बनेगा. सो दिस इज डुअलिस्टिक थ्योरी. और ये कहाँ प्रेवलेंट है? मेजॉरिटी ऑफ द कंट्रीज फॉलो डुअलिस्टिक थ्योरी. सो फर्स्ट एग्जांपल इज यूके लीगल सिस्टम. सो यूनाइटेड किंगडम्स follows a dualistic approach where international treaties need to be enacted through domestic legislation before they become part of the national law. तो अगर कोई भी ट्रीटी अगर वो चाहता है इनकॉर्पोरेट करना यूके, देन दे हैव टू मेक अ सेपरेट लेजिस्लेशन, then it will become part of their domestic system. Next is US. US requires that international treaties to be ratified by the Senate, and then it should be through legislative process, and then it will become a domestic legislation. And similar is the case with India. India also follows dualistic approach. In detail I have dealt with India, so we'll see that in another slide. Monoism and dualism. So I have bifurcated them and I have also included implication. मतलब क्यों पढ़ना है और क्यों important है dualism और monoism theories. So monoism is a legal theory जो ज़्यादा supremacy international law को देता है और बोलता है एक single unified system है international और domestic law, direct applicability है, और अगर कोई भी problem होती है दोनों laws में, domestic and international में, then international law will prevail. डुअलिज्म क्या बोलता है कि दो डिफरेंट लीगल सिस्टम है और ऑटोमेटिकली एप्लीकेबल नहीं होगा. देयर शुड बी अ प्रॉपर अडॉप्शन ऑफ इंटरनेशनल लॉ थ्रू लेजिस्लेटिव प्रोसेस. अब इन दोनों थ्योरीज का इम्प्लीकेशन क्या है? दिस थ्योरी हेल्प्स अस इन अंडरस्टैंडिंग द डिफरेंस बिटवीन these theories and also international law, municipal law, and also the stand taken by different countries, because every country has a right to choose the theory as they want. So India has chosen dualistic approach, US, UK has chosen dualistic approach. So international law does not become part of their domestic system automatically. उनको अलग से बनाना पड़ता है legislation, तब जाकर वो उनके domestic system का part बनता है. Let's start with India's dualistic approach. So to understand the relationship between international law and domestic law in India, we have to understand that India has chosen the dualistic approach. So under constitutional provision also, Article 51C says that state to respect international law and treaty obligations, but it does not automatically incorporate international law into domestic law. So this particular article is stating India's stand that we do not support monoism, or we do not want monoistic approach in the country. We are going for the dualistic approach. So हम लोग international treaty और international law के obligations respect करेंगे, but वो डायरेक्ट या ऑटोमेटिकली पार्ट नहीं बनेगा डोमेस्टिक लेजिस्लेशन का. नेक्स्ट इज आर्टिकल 253 विच ग्रांट्स द पार्लियामेंट ऑफ इंडिया द पावर टू मेक लॉज फॉर द एंटायर और एनी पार्ट ऑफ द कंट्री फॉर इम्प्लीमेंटिंग एनी ट्रीटी अग्रीमेंट कन्वेंशन with any other countries or any decision made at an international conference, association or other bodies. So this one is talking about the parliament's power to make laws or legislations by taking reference from treaty अग्रीमेंट और कन्वेंशन. जैसे अगर कोई भी कन्वेंशन होता है, इंडिया रैटिफाइज इट, मतलब अगर उसको साइन करके आता है, ठीक है, वी विल फॉलो इट, तो ऐसा नहीं वो सिग्नेचर से वो डायरेक्ट डोमेस्टिक लॉ में एंटर कर जाता है. टू इम्प्लीमेंट दैट, इंडिया through this article 253 has to through legislative process enact a separate act so that it can become part of the domestic legal system. This is a constitutional provision advocating for the dualistic approach in India. Now let's look at the legislative action. So international treaties and conventions do not automatically become part of Indian law. They require legislative action. मतलब legislative process के through, parliament के through एक domestic law बनेगा. This means that international agreements must be ratified and then enacted through domestic legislation by the parliament. पहले sign होगा इंडिया के through and then through domestic legislation by parliament it will become part of the domestic system. Next is judicial interpretation. So Indian judiciary sometimes uses international conventions and treaties to interpret and expand the scope of fundamental rights. क्या होता है ना, कभी कभी अगर कोई केस आता है कोर्ट में और उसमें अगर कोई गैप हो, लैक्यूना हो, तो उसके लिए जो जजेस होते हैं वो इंटरनेशनल ट्रीटीज और कन्वेंशन जिसको इंडिया रेटिफाई करती है उससे भी रेफरेंस लेते हैं, दैट व्हाट इज गिवन अंडर दैट, क्या गाइडलाइन है। तो ऐसा ही एक केस हुआ था विशाखा वर्सेस स्टेट ऑफ राजस्थान में, ये 2013 का केस है। ये सेक्सुअल हरासमेंट एट वर्क प्लेस का केस था। तो इस टाइम पर इंडिया में कोई भी लॉज नहीं थे जो सेक्सुअल हरासमेंट एट वर्क प्लेस से डील करे। सो व्हाट द सुप्रीम कोर्ट डिड, they used the convention, this is the convention on the elimination of all forms of discrimination against women, इसको शॉर्ट में CEDAW भी बोलते हैं। तो इस कन्वेंशन से रेफरेंस लेके, क्योंकि उसमें मेंशन था सेक्सुअल हरासमेंट एट द वर्क प्लेस, the Supreme Court took reference from this convention and gave certain guidelines। फिर कुछ टाइम के बाद एक प्रॉपर एक्ट बनकर आया जिससे इसके जो गाइडलाइंस है, इसके जो ऑब्लिगेशंस है CEDAW के, वो डोमेस्टिक सिस्टम का पार्ट बना इंडिया में। So in summary, India's dualistic approach ensures that while the country respects and acknowledges the international obligations, these obligations do not become part of domestic law without the explicit legislative action. So we know that India follows dualistic approach, and to have the international law in India, we need proper legislative process or action. Application in national legal system. So again, we will use the definition that we have for dualism and monoism. So to understand this, we have this particular chart where it is, the first is individual, and on individual applies the municipal law, then international law. But according to the monoism, these two are same legal system, so they will be unified in a manner to apply over the individual. But this is not the case in dualism. Dualism में ये तीन layers रहेंगे, जहाँ पे पहले municipal आएगा, then international law, because we know dualism gives importance to state sovereignty and monoism gives importance to international law. So this is the application of monoism and dualism in the national legal systems. Comparison of monoism and dualism. So I have included this chart to make it more clear and easy to understand. So application wise, monoism is directly and automatically included in the national legal system, and under dualism it requires a domestic adoption or process or transformation, that there should be a legislation or there should be a legislative process through which the international law will become part of the municipal law. Next comes the primacy, it means the importance. So under monoism, international law is given more importance over domestic law, but under dualism, national law is considered separate and superior. Now comes the flexibility, so potential for easier adaptation to international standards, and under dualism it is much more complex, and also it is difficult because if some countries wants to include some international law into their domestic legal system, but some countries may not want to, so this creates a imbalance in the international law. तो यहाँ पर क्या हो रहा है, जो इंटरनेशनल लॉ है वो म्यूनिसिपल बन जा रहा है लॉ, लेकिन यहाँ पे जो कंट्रीज अपने विल से अडॉप्ट करती है सिर्फ वही बनता है। तो इससे क्या होता है, बहुत सारी कंट्रीज में कुछ इंटरनेशनल लॉज हैं, कुछ नहीं है। सो दिस monoism is more flexible in terms of international law, and this is more rigid and complex. These are some of the case clauses relevant in the Indian context for stating the India's stand for dualistic approach. So the first one is Re-Beruberi case, which was filed in 1960. In this case, the Supreme Court clarified that any agreement or treaty with any another country which is affecting the Indian territory requires a constitutional amendment under Article 368. Automatically वो part नहीं बनेगा because we follow dualistic approach. So it has to be adopted through a legislature, that is the parliament. Next is the Ram Kishore Sen versus Union of India. It happened after 6 years of Re-Beruberi case, that is in 1966. So under this also the judgment stated the necessity for legislative action to give effect to the international treaties within India. मतलब automatically part नहीं बनेगा, legislative action या प्रोसेस जरूरी है किसी भी इंटरनेशनल ट्रीटी कन्वेंशन को इंडियन डोमेस्टिक लीगल सिस्टम का पार्ट बनने के लिए। नेक्स्ट इज जॉली जॉर्ज वर्गीज वर्सेस बैंक ऑफ कोचिन। इसमें जो था एक इंटरनेशनल कन्वेनेंट था, दैट इज ICCPR। तो इसको कोर्ट जो था इसमें इन्वॉल्व करके ह्यूमन राइट्स को एम्फेसाइज किए थे, दैट Such international covenants are not enforceable in domestic courts unless they are incorporated into domestic law. So these cases states that how judiciary and uh, legislature has played together to have a better dualistic approach in India. So through this case, judiciary has played its role in stating India's clear stand that we have adopted dualistic approach, because for India, international law and municipal law are two distinct systems, and there should be a legal and legislative process for the adoption of any international law in the domestic system. These are more cases which are related to the dualistic approach of India. So the fourth one is Gramophone Company of India Limited versus Birendra Bahadur Pandey, 1984. So under this case, the Supreme Court referred the Berne Convention. This convention talked about the copyright issues and protection of literary and artistic work. But the court emphasized that international treaty will not become part of Indian laws unless they are enacted through legislature. So this case again reaffirmed the dualistic approach that India has. Next is the Union of India versus Sukumar Sen Gupta, 1919. Again, in this case, the principle that international treaties and conventions need to be translated into domestic legislation before they can be enforced in the Indian legal system was highlighted. So the parliamentary approval was given emphasis. So the necessity is given in under this case. Next is the Vellore Citizens Welfare Forum versus Union of India. This was filed in 1996. Under this case, the court used the international environmental principles such as precautionary principle and polluter pays principle. And court said that if international principles are not violative of domestic laws and policies, and so they can be enforceable. So this case highlighted how international principles can influence domestic jurisprudence but still require a basis in domestic law for enforcement. So this case law is very important since it is giving recognition to dualistic approach, but meanwhile it is also talking that if there are any principle which is not contrary or which is not violative of any Indian laws, then court can use such principle. So Vellore Citizens Welfare Forum versus Union of India, 1996 case. Another case is the Vishaka versus State of Rajasthan. So we have already talked about this case. This case is relating to sexual harassment at workplace. So during this time when this case was filed, there was a major lacuna or gap. कुछ इसके ऊपर कोई प्रिंसिपल या कुछ रूल्स नहीं था. सो द कोर्ट टुक रेफरेंस फ्रॉम द सीडॉ. एक कन्वेंशन था विच टॉक्ड अबाउट सेक्सुअल हरासमेंट एट वर्क प्लेस. सो इंडिया gave judgment and gave few guidelines taking reference from CEDAW, and later on a separate legislation was made dealing with sexual harassment at workplace. So international law became part of domestic law through legislative process, which was held by the judicial interpretation. Next is the Justice K.S. Puttaswamy versus Union of India, 2017. So in this case, the court took reference and acknowledged the international human rights instrument, that is UDHR and ICCPR, and made right to privacy our fundamental right. So this also talked about the enforceability of these rights with India in the constitutional provisions and domestic laws, and reinforcing the dualistic framework, meaning that हम लोग international laws भी acknowledge करेंगे while deciding some matters, and we will also have a dualistic approach. This was your unit 3, that is the relationship between international law and municipal law. So a question may come directly under this also, like explain the relationship between international law and municipal law, or a short note may come on dualism or monoism. So you can write the entire answers together, or if a short note comes, then choose any one theory or two theory and write to incorporate examples like UK US में dualistic है, Netherlands में monoistic है, India follows dualism. So these things can be included in your answer to make it a lengthy one. So all the best for unit 3.